Alright, well today has been a double day. We actually are posting two videos today and it's a little bit of a surprise, but we had to do them separately because they are separate topics. In a previous video that I just posted regarding Missouri medical marijuana's most recent news with the expungement of prior marijuana convictions for patient identification card holders. And now we're going to talk about the United States Court of Appeals for the Sixth Circuit. The Sixth Circuit has just upheld a long-held belief that the middle finger is constitutionally protected. You can fly the bird at the police, and you are protected constitutionally. This is free speech. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. This is free speech.
Oh, well, everybody's heard about the
another
bird.
variation, however people do the flopping. Yeah. But you can't fly the bird, man. Give them a good one. These are good scripts. Now, let's talk about the actual book. My helper here is raising an eye. She doesn't think that was appropriate. So let's talk about the court case. In Deborah Lee Curtis Gullis, I just slaughtered her name, I apologize, v. Matthew Wayne Menard in the state of Michigan. The facts of this are pretty simple. She was driving her car and allegedly was speeding. She was pulled over by Officer Menard, a Taylor police officer. Menard stopped her, wrote her a non-moving violation. She received the ticket and on her way away from the officer, graciously waved to him, bye. And at which point he decided to pull her over less than 100 meters from the original stop and wrote her a upgraded ticket and gave her a ticket for the speeding violation. Now, Ms. Gullis, obviously, Ms. Cruz Gullis, obviously feels that that was inappropriate. That was a violation of her First Amendment rights. And in fact, it is. This case looked at that. The court opinion is actually related to Menard's attempt to dismiss because he claimed qualified immunity. However, it's a long-held principle that you don't have qualified immunity when you knowingly violate somebody's civil rights. And a reasonable officer should know that this is protected speech. We've had this discussion in other videos of mine, and I'm sure you've seen it. Fuck the police is protected political speech. Fuck you, police, is not. There is a difference. This is protected political speech. It's communication, and you can do it. That doesn't mean it's nice, it doesn't mean it isn't crass, it doesn't mean it isn't rude. It certainly is all of those. But it's protected. They cannot issue you a ticket, a summons, without exposing themselves under 1983. So, Miss Gullis sued Officer Menard under Section 1983, alleging that he violated her constitutional rights with the second stop. Okay, and changing the original ticket to a more serious speeding and points violation. She claims that he unreasonably seized her in violation of the 4th and 14th Amendment, retaliated against her because of her protected speech in the first 14th Amendment, and restricted her liberty in violation of the Due Process Clause of the 14th Amendment. Now, he moved for a judgment on the pleadings based on qualified immunity. The district court denied that motion, correctly reasoning that Ms. Gullis could not be stopped a second time in absence of a new law violation, and that she had a free speech right to make the gesture. Menard filed an interlocutory appeal, arguing that he was entitled to qualified immunity because even if he had violated her constitutional rights, those rights were not clearly established. And by the way, they were. Now, qualified immunity protects police officers from personal liability unless they violate a person's clearly established constitutional or statutory rights. And that's pretty clear. The qualified immunity can be a big hurdle at times. There has to be a clear violation. Now, everyone agrees that Menard did violate her right to be free from an unreasonable seizure by stopping her a second time. Okay, under the facts set forward in the complaint, that's clear. All the justices in the Sixth Circuit agreed that all the judges in the Sixth Circuit agreed that Minard seized Cruz Gulius within the meaning of the Fourth Amendment when he pulled her over that second time. To justify the stop, he needed probable cause that she had committed a civil traffic violation or reasonable suspicion that she had committed a crime. I'm sure you've all heard that before. Now, any authority to seize her in connection with the previous infraction ended when that stop concluded. Now, that's a court case about extending stops inappropriately called Rodriguez v. United States. I'm not going to go into that case right now, but it is a very impactful case for traffic stop extensions, continuations, other crimes investigations, searches, and general pain in the ass behavior. Now, the only item remaining for cause for the second stop was Miss Cruz Gulius's gesture. Now, that gesture doesn't violate any law that was identified in the state of Michigan by the officer. And the officer didn't argue that it was illegal or violated. And there is clearly case law that shows that they simply cannot stop somebody for communication. Now, the court runs through other aspects of this case, and it's a pretty good breakdown for the summary that it is. Clearly, the Sixth Circuit did not feel a need to go in detail because these are clearly established rights. The law does require independent justification for the second stop. See Rodriguez. No matter how Minard slice it, the gesture cannot provide that justification. And her allegations survived his motion for judgment on the pleadings based on qualified immunity. What that means is this case still has to be heard by the district court for the 1983 action. This also means that it's likely going to be settled by the officer and the township. They're not going to go to trial on this because it is a clear dog loser. Now, she alleged that he violated her free speech rights for the stop, and to win that, she has to show that she engaged in protected conduct. Okay, that this is protected conduct. That he took an adverse action against her that would deter an ordinary person from continuing to engage in that conduct. And her protected conduct motivated him, at least in part. So, this is protected. The officers stopping her a second time and issuing her an upgraded citation is an action that would deter an ordinary person from continuing in flipping off the police officer. And it was the flip-off that motivated him, at least in part. Okay. Precedent clearly established the first and second elements here. Any reasonable police officer would know that a citizen who raises their middle finger is engaging in speech protected by the First Amendment. Okay, there is no question about that. Cohen v. California, Sandul v. Larian, Sandul, S-A-N-D-U-L v. L-A-R-I-O-N. Okay, an officer who seizes a person for Fourth Amendment purposes without proper jurisdiction and issues her a more severe ticket commits an adverse action that would deter her from repeating that conduct in the future. That is that second prong. He has definitely taken action to deter her from continuing that conduct. Okay, that is a violation of her Fourth Amendment. Now, in view of the reality that something as trivial as failing to hold a birthday party for a public employee amounts to retaliation if done because the employee exercised free speech rights, then clearly an unwarranted police stop, a far greater intrusion on liberty, must satisfy that test. An unwarranted police stop must satisfy that test. And then the third element, the fact-intensive question for this instance is, did he stop her because she made the gesture? That counts as a cognizable and clear violation of her free speech rights. Yes, he does. So, that's a very concerning thing, but the court got this right down the line on their assessment. So, as of right now, in the 6th District, and well, frankly everywhere, but the 6th District's opinion is controlling the 6th District, and it is persuasive authority in the sister districts. But most of them have ruled, and they're following Supreme Court precedent as well. So, flipping off the police is protected political speech. If a police officer takes a derogatory action against you by seizing you, holding you, writing you a ticket, something like that, that will very likely open up that officer to civil suit. So for the police officers, I know it pisses you off. Don't stop them for contempt of cop. Don't do it. It's going to start costing money. For the activist, you really don't need to run around flipping off cops, but if you do, it's protected. Please like and subscribe. Don't forget to hit that alert button. Thank you.